Let's begin with business and immigration law updates. This will be presented to us by Attorney Ramesh Khurana of the Khurana Law Firm located in Rockville, Maryland. The moderator here is Mr. Kenneth Haber, Attorney at Law. This week, Attorney Khurana will provide us with vital information on DOL and LCA updates, as in the H-1 program. Let's take a look.
Welcome to the Capitol Forum. I'm Kenneth Haber, your moderator today, and with me is Ramesh Khurana, well-known immigration attorney who has clients across the country and across the world. Ramesh has helped numerous people over the years come and settle here in the United States, get work here in the United States, and he's here to share his experiences and knowledge in this ever-evolving area of law. Can you give us some insight into the Department of Labor's wage and hour investigation from me?
Sure. Kenneth, first of all, I would like to thank you for a very good introduction and for being so generous to me. I agree with you. The immigration law is really evolving. I tell you, Kenneth, if I don't check my mailbox tonight, I'll be missing something important. And clients are so enlightened these days. They are so much educated. Next day, they ask me some questions, and if I have not read those areas, I'll be missing something, and I will be looking bad in the eyes of my clients. It is really everyday evolving regulation, law, practices, etc. I'm thankful to you for reminding me that one.
Well, law is an evolving process, but I think immigration law is evolving that much faster than most areas of the law.
I agree with you. This is Department of Homeland Security, right?
Yes. The Department of Labor, I understand, undertakes investigations concerning the labor condition applications concerning the H-1B visa program. Can you enlighten us a little bit about that?
Yeah, sure. Like we have discussed at length in our previous segment, what is the importance of the labor condition application? I already told the audience that whatever attestations, whatever representations, whatever information you incorporate on the labor condition application, make sure you stand by those attestations. Those have got to be true. Now, for example, if you say that we have to pay $60,000 for this particular position in a year, make sure that you pay at least $60,000 to the employee. Employee should not be asked to bench, or he should not be taken out of the active employment status or non-productive status. Make sure he is fully paid. I have seen many complaints which are coming from the frustrated employees who have not been paid, and these guys would file complaint with the Wage and Hour Division of the U.S. Department of Labor, and U.S. Department of Labor is not in a mood to forgive these kinds of violators of LCA conditions. Can I tell you, they come very tough on these kinds of violators, and they make sure the employees get paid.
What sort of documentation does an employer need to present to the Department of Labor during these type of investigations?
It all depends what kinds of documents are asked for by the U.S. Department of Labor. But in my practice, I have seen that they would like to ask the employer about the pay records of the company. It's very simple, because they like to see from the pay records of the company, and especially for the employee for whom the investigation is being conducted, like whether this employee has been paid full wages pursuant to the labor condition application or not. Then they would say, okay, give us a copy of the labor condition application. Maybe employee was working on location B, and he moved to location B, and if the employer has not filed any labor condition application for the change location, it's a violation. So they would ask for the copy of the LCA. Then what we call a public access file. So they would like to ask them, give us a copy of the public access file, because they like to make sure that all those regulations are strictly complied with. So again, depending upon the situation, like what is the nature of the complaint, based on the nature of the complaint, they may tailor some of the questions for the employers.
What are some of the penalties that could be imposed in case the Department of Labor found a violation?
Again, it depends what kinds of violations have been committed by the employers, and this, I would say that this is a violation specific penalty, but penalties could be very serious and broad, like they could be fined and they could be even barred from filing other H-1B petitions. Like if they see that this person has been violating these regulations and there are serious violations, they will say you can no longer file H-1B petitions. And even the petitions which are already approved, they may even go to the extent of saying we are going to withdraw these approved petitions. They come very, very tough. Apart from that, penalties could be in terms of payment of non-paid wages. If a person has not been paid his wages which were supposed to be paid pursuant to the labor condition application, whatever is the shortfall, they will say pay the shortfall to the employee. They have to pay. And the good news is these kinds of people don't have to hire even lawyers, because it's the Department of Labor which is keeping an eye on the employers, and they represent these kinds of employees who are the complainants in this case. Sometimes I have seen, Ken, that investigation could be started by the Department of Labor on a random basis, because they would like to investigate one particular employer on a random basis, and in that case there is no complainant, but then they ask for the records of the all H-1B employees. Even if there are 100 employees, it's a lot of work for the employer to do that. I have been associated with some investigations which have been conducted by the Department of Labor, and I have seen in my practice it's very tough. It's a kind of non-productive work for the employer. This is what they say, but I would say it's very productive. Pay full attention to what is required by the Department of Labor. Otherwise, you could be subject to heavy civil penalties.
When's the employer's obligation start as far as paying these wages?
Again, very interesting question. Now, it starts when the H-1B petition is approved and the person has entered into an employment agreement. Most important factor here to be determined is whether the employee is available to work. If the employee is available to work, the obligation to pay that employee begins now. To give you an example, a person comes on H-1B visa from India. He doesn't have a social security number, so he is to apply for the social security. That doesn't mean that employer doesn't have to pay him, even though he is going through some licensing process or he is trying to take care of some other logistics. But if he has become available, he is entitled for the wages from that particular day. I have seen in investigations like people who said, he was not available, he didn't have the social security number, to give you an example, so I didn't pay. No, you have got to pay him while the social security request is being processed. Now, your second question was when the requirement to pay wages ceases, I believe, right?
Yes.
It ceases when the employee's job is terminated or he resigns. Then of course he doesn't have to pay.
Could you please explain the obligation to continue to pay the H-1B employee and until what time?
Yeah, again, continue to pay the H-1B employee so long as that person's job is not terminated. That means person is still on the payroll of the company. I think this question becomes more relevant in the context we talked about the benching concept. And you are asking that person, I do not have a project for you, I cannot pay you. No, you have got to pay him. It is not the responsibility of the employee to find the project. This is the responsibility of the employer to find the project for that employee. and likewise I have seen in the respect of part-time employees. Now, employer would file a labor condition application for approval of H-1B petition, and he will say that this person would work for 15 hours a week. So, you have got to pay him for 15 hours a week. It is not that you just pay that employee for 10 hours. This will be called again violation of the LCA condition, and the liability to pay to that employee for 15 hours does not cease.
Is there a minimum number of hours they have to agree to employ the employee?
It all depends how many hours are indicated on the labor condition application. If it is a full-time job, these are 40 hours or even 35 hours per week would amount to a full-time job. But if it is not a full-time job, you can reduce it to 30 hours, 20 hours depending upon what is the requirement of the company. Now, I have seen in my practice, if somebody is not required for the full time, employer says, well, I want to hire him as an accountant just for 20 hours a week. USCIS does not have any problems. And the good news is, if this particular employee who has been hired for 20 hours a week by that particular employer, he can find another employer to work 20 hours or 25 hours, but he will have to file another H-1B petition basically to work with that employer. I mean, that employer would file. So, he could have two jobs simultaneously.
Is there any penalty to the employer if he puts in his papers for 20 hours and turns around and decides he wants to work the employee for an extra 10 hours or an extra 20 hours and let that go up and down starting at the lower 20-hour level?
That is a good question, Ken. So long as the employee is working and getting paid for the amount of number of hours which are stipulated on the labor condition application, I think he is not violating the labor condition application. So, if it says 20 hours and you are asking that person to work for 15 hours a week, he has to pay that person 20 hours a week. But once in a while, if you think that that person's services are required instead of 20 hours, 25 hours, that is fine. But if on a regular basis, it is seen by the employer that you need that employer to work for 35 hours or 40 hours a week, which amounts to a full-time job, then they have to file an amended petition and another labor condition application.
If they don't file, is there a penalty for working the person?
Again, it's a violation of the LCA, and it's also a violation of the material conditions of the H-1B petition, which was approved by the USCIS.
Gets rather complicated.
Yes, employers have to stay on top of the compliance arena. I always advise my clients, don't take any chances with the compliance issues.
Well, I really like to thank you for coming on to the Capitol Forum and enlightening us into this complicated area of law. Thank you.
I thank you very much, Ken, for inviting me here, and I also appreciate that audience has been very patient with us, and I will always advise, as usual, kindly consult with your immigration attorney if you have any questions. Thank you so much.